All right, this is the 140-160 class. This is going to be some literary warm-up. For the record, the U.S. Supreme Court, having virtually wiped out the death penalty some years ago, has subsequently restructured the penalty within limits and continues to refine its guidelines. In a landmark decision, Furman versus Georgia, the High Court held unconstitutional Georgia statute which gave the jury complete and unguided discretion to impose the death penalty or not, as it saw fit. That decision stopped capital punishment in its tracks while state legislatures struggled to devise laws to comply. Several states subsequently enacted statutes withdrawing any discretion on the jury's part by making the death penalty mandatory upon a finding of guilt. Actual experience with laws like that indicated that many juries were acquitting clearly guilty defendants if the jurors felt that the defendant did not deserve to die for his crime. In a North Carolina case, the court held that this was as bad as the situation that existed before the Furman decision. The Supreme Court further defined its position on June 20 in a case arising in Alabama. Alone among the states that have capital punishment statutes, Alabama's law provides that a jury in a capital case cannot convict a defendant of an offense similar to but lesser than the one charged. The defendant in the case that reached the court admitted on the stand that he and an accomplice had participated in a robbery of an 80-year-old man. He denied, however, that he had killed the man or intended to. He said he had seized the victim and was about to bind him with a rope when his accomplice unexpectedly hit the man and killed him. Under Alabama law, he could have been charged under these circumstances with felony murder, which is a lesser offense than the one with which he was charged, robbery, intentional killing, a capital crime. The trial judge was prohibited by law from instructing the jury of the lesser offense. He was required to tell the panel that they could find the man guilty of robbery with intent to kill and give him the death penalty or free him completely. A third option, of course, was to arrive at no verdict, thus creating a mistrial. The defendant was convicted and sentenced to die, thus setting up the appeal. Under common law and under many former state statutes, juries were permitted to find a defendant guilty of less severe offenses. This sensible safeguard remains in federal law and in the laws of most states that permit capital punishment. Just the other day, for example, the South Carolina Supreme Court set aside a death penalty and sent the case back for resentencing when the trial judge failed to instruct the jury that it could recommend a life sentence rather than the electric chair. The Alabama statute does not include this alternative, and the Supreme Court properly shot it down. Justice John Stevens wrote that if the evidence unquestionably establishes that the defendant is guilty of a serious violent offense, but leaves some doubt that the death penalty is appropriate, failure to give the jury the third option of convicting on a lesser included offense would seem inevitably to enhance the risk of an unwarranted conviction. Such a risk cannot be tolerated in a case in which the defendant's life is at stake. While this ruling has limited application at present, it will serve to guide states that may wish to impose a death penalty or amend present statutes. It is thus a potentially valuable addition to the law. Just some more literary. This one's on product liability, for the record. In recent months came the news that a jury in a federal court in Oklahoma City had awarded the estate of the late Karen Silkwood $505,000 in actual damages and $10 million in punitive damages. The suit alleged negligence on the part of Kerr-McGee Corporation in the operation of a nuclear facility where the woman worked as a lab technician. The award was made despite defense testimony that the plant had been operated in compliance with government safety standards and despite testimony that the woman might have contributed to the contamination she suffered. Incidentally, she did not die of whatever exposure she suffered. She died in an auto accident. We have no knowledge of the facts in that case other than those reported in the press, but we cite as an indication of how willing juries are inclined these days to make huge awards to individuals who have brought negligence suits against large companies, supposedly backed by rich insurance companies. As a further example of the prevailing mood, we note that one of the Silkwood lawyers urged individuals living around the damaged 3 Mile Island nuclear plant in Pennsylvania to go like gangbusters in filing suits. No doubt he would be happy to go there and take some cases on contingency fees, which means he would get 1/3 or more of the awards if he wins. A number of examples of the nation's litigious trend have surfaced here in South Carolina in the product liability field, to cite only one area of mounting concern. The Insurance Information Institute reports that Little South Carolina had the 6th highest number of lawsuits based on product-related claims filed in federal courts during fiscal 1978. Most of them concerned manufactured products which were involved in personal injuries at some time subsequent to sale. A manufacturer's liability for a defective product may last for many years, even if the product was altered by the user or not used for its original purpose. The trend is to fix liability even if the manufacturer complied with all safety standards and employed all of the technology available at the time of manufacture. Failure to warn of all potential hazards can cost a company. Fabergé Inc., for example, argued that it could not have reasonably been expected to foresee that a teenager, intent on scenting a candle, would pour its perfume on an open flame, causing it to ignite and burn another teenager's neck. Fabergé nonetheless had to pay $27,000. One obvious result of this trend is soaring insurance rates, which are particularly painful to small companies. This can chill product development and cost jobs. We know of one South Carolina-based manufacturer that decided not to make a new line of ladders when it learned how much product liability insurance would cost. And of course, high premiums are running up consumer costs. Efforts are being made in South Carolina House of Representatives to get action on a bill placing certain limits on product liability, including that length of time after manufacture that the liability continues. About 1/3 of the states have passed legislation in this area to curb the excess in the courts. Plaintiffs' attorneys, of course, do not like such bills, and they have a great deal of power in most state legislatures. But a balanced bill that offers adequate protection to injured parties without imposing undue costs on manufacturers and the general public is certainly needed in this suit-happy society. All right, this will be some jury charge material for the record. Mr. Foreman and ladies and gentlemen of the jury, you have heard all of the testimony in these cases. You have heard the arguments or the summations of the attorneys. It now becomes my duty to state to you the law that applies to cases of this type. It is your duty to make a determination of the facts in the case. It is for you to decide or determine just what did or did not happen. You apply those facts as you find them to be to the law as I shall state it to you, and thereby arrive at a proper verdict. Now, under the laws of our state, I am not permitted to comment upon the facts in the case. You, the jurors, are the sole and exclusive judges of the facts in each case. The facts are for your consideration. The facts are for your determination. I am satisfied that you are fully capable of determining them. As I have just stated to you, it is my duty under the laws to state to you the law that is applicable to the case in order that you may apply the facts as you find them to be and render a proper verdict. It would be a violation of your duty to attempt to determine the law or to base a verdict upon any other view of the law than that given to you by the court, a wrong for which the parties would have no remedy because it is conclusively presumed by this court and by all higher courts that you have acted with these instructions as you have been sworn to do. So, Mr. Foreman and ladies and gentlemen of the jury, you are here for the purpose of trying the issues of facts presented by the allegations in the indictments and the plea of not guilty of each of the defendants. This duty you should perform uninfluenced by pity for the defendants or any one of them, or by passion or prejudice on account of the nature of the charges against them. You are to be governed, therefore, solely by the evidence introduced in this trial, and the law is given to you by the court. The law does not permit jurors to be governed by mere sentiment, conjecture, sympathy, passion, or prejudice, public opinion, or public feeling. Both the state and the defendants have a right to demand, and they do so demand and expect, that you will carefully and dispassionately weigh and consider the evidence and the law of the case, and give to each your conscientious judgment, that you will reach a verdict that will be just to both sides regardless of what the consequences may be. Now, the offense with which these defendants are charged in these indictments is that of conspiracy, of arson, and of burning personal property to defraud an insurance company. And in this connection, Mr. Foreman and ladies and gentlemen of the jury, I instruct you that these indictments are mere charges or accusations against these defendants. It is not any evidence of the defendant's guilt, and no juror at this stage should permit himself or herself to be influenced against the defendants because of or on account of the indictments. It is the duty of the jury to decide whether the defendants or any one of them be guilty or not guilty of the offenses charged, considering all of the evidence submitted to you in this case. Now, Mr. Foreman and ladies and gentlemen of the jury, you are also the sole and exclusive judges of the effect and the value of the evidence addressed to you. You are also the sole and exclusive judges of the credibility or believability of every witness who has been sworn, who has taken the stand, and who has testified in this case. It is for you to say what weight, what belief you shall put in the testimony of every witness. Now, in making that determination, take into consideration the fact as to whether they have spoken the truth. You may look not only at the manner of the witnesses while on the stand, their relation to the case, if any, but also their degree of intelligence. Every witness is presumed to speak the truth. This presumption, however, may be rebutted by the manner in which the witness testified, his interest in the case, if any, or any bias or prejudice, if any, against one or any of the parties, by the character of his testimony, or by evidence affecting his or her character for honesty or integrity, if any, or by contradictory evidence, if such there be. And again, Mr. Foreman and ladies and gentlemen of the jury, you are the exclusive judges of the believability of every witness who has been sworn, who has taken the stand, and who has testified in this case. And again, in passing upon the credibility or believability of witnesses and in deciding what weight you shall attach to their testimony, you must consider all of the circumstances, their opportunity for knowing what they testify to, their conduct and demeanor upon the witness stand, the influence under which they testify, the inducements held out to them, and everything which is calculated to bias and influence their views and judgment. And then you say what weight you will give to their evidence or testimony. I further charge you that the testimony of a witness may be discredited or impeached by showing that the witness has been convicted of a crime involving moral turpitude. Now, prior conviction does not render a witness incompetent to testify, but is merely a circumstance which you may consider in determining the credibility or believability of that witness. It is the province of the jury to determine the weight to be given to any prior conviction as impeachment, and as I stated to you, it is your responsibility to determine and to decide what weight you shall attach to the testimony of every witness.